Question 401. Broker Gary arranged a second trust deed amounting to $9,000 for Raul, and asked Raul for a commission of $1,200. Gary's commission charge is A. Legal, because Gary can charge whatever commission he chooses. B. Illegal, because it is over the amount allowed by law. C. Invalid, because the California Association of Realtors does not allow commissions for second trust deeds. D. Legal, because it complies with allowable commission percentages for second trust deeds. Correct answer is D. Legal, because it complies with allowable commission percentages for second trust deeds. According to the real estate law, a loan of less than $20,000 for a 3-year term or more can result in a commission up to 15% of the loan amount. 15% of $9,000 is $1,350, so the $1,200 commission charge is permissible. A second trust deed, also known as a junior loan or subordinated loan, is a type of loan that allows a property owner to use their property as collateral for an additional loan. The first loan is called the first deed of trust, and the second loan is recorded against the property that already has the first loan. The borrower keeps the existing mortgage, but can take out another loan against the property. Question 402. In their first meeting, an owner tells a broker that the property should not be shown to any persons of color. Upon hearing this, the broker should A. Accept this listing under the reasoning, if the broker doesn't take it, another broker will. B. Explain to the owner that there are less obvious ways to make sure the property is sold to the right kind of person. C. Advise the owner that, if he wishes to discriminate against certain persons, then the owner should sell the property himself. D. Refuse the listing. Correct answer is D. Refuse the listing. Discrimination based on race, color, and other protected classes is illegal in the United States under the Fair Housing Act. Accepting the listing would make the broker complicit in this discriminatory practice. Real estate brokers have a professional code of ethics that requires them to treat all potential buyers and sellers fairly. Accepting a listing based on discriminatory criteria would be a violation of this code. For that reason, refusing the listing is the only option that protects the rights of potential buyers and upholds the broker's professional obligations. Question 403. A dam breaks, and the rush of freed water washes away most of a real property. This is called A. Avulsion, B. Accretion, C. Reliction, D. Rescission. Correct answer is A. Avulsion. Accretion is the gradual and imperceptible addition of land by the deposit of sediment or soil by natural forces like water. Reliction is the gradual recession of water from its usual watermark, permanently exposing land that was previously submerged. In a legal context, rescission is the cancellation of a contract, putting the parties back in their original positions as if the contract had never been made. It has nothing to do with physical changes to land. Avulsion refers to the sudden and perceptible tearing away of land by the violent action of water or a sudden change in the course of a stream or river. The breaking of a dam and the resulting rush of water washing away property fits this definition perfectly. It's a sudden and dramatic loss of land due to a natural force. Question 404. Judgment liens and mechanics liens differ because A. Judgment liens cannot be enforced unless they are recorded. B. Mechanics liens are created by statutory law. C. Judgment liens are imposed involuntarily. D. Mechanics liens can take priority earlier than when they are recorded. Correct answer is D. Mechanics liens can take priority earlier than when they are recorded. Mechanics liens are enforceable dating back to the day construction was started, while judgment liens are not. Judgment liens arise from a court judgment against a debtor. It's imposed involuntarily, meaning the debtor has no control over the placement of the lien and require recording for enforcement. Mechanics liens created by statute to protect contractors and suppliers who are not paid for their work or materials. It filed by contractors or suppliers to secure payment. Can take priority over other liens even before recording. Question 405. The concept of latches in real estate matters relates to A. Door locks. B. Water rights. C. Quality of construction. D. Failure to bring a claim in a timely manner. Correct answer is D. Failure to bring a claim in a timely manner. Latches is a legal principle in California real estate law that prevents property owners from delaying claims about their property for too long. It's an equitable doctrine that allows courts to deny relief to a claimant if they unreasonably delay asserting their claim. The justification for the doctrine is that the delay was unreasonable on the part of the plaintiff, and the changed conditions due to the delay render granting the relief sought inequitable. If the delay on the plaintiff's part can be satisfactorily explained by some reason like lack of information, the delay may be excused. Question 406. In this type of listing, the seller pays a commission to the broker even if the owner sells the property himself. A. Exclusive agency listing. B. Net listing. C. Open listing. D. Exclusive right to sell listing. Correct answer is D. Exclusive right to sell listing. In a net listing, the seller agrees to accept a specific net amount from the sale of the property, and the broker retains any amount exceeding that as their commission. While legal in some states, they are often discouraged due to potential conflicts of interest. The commission payment isn't tied to who finds the buyer in the same way as an exclusive right to sell. In an open listing, the seller can hire multiple brokers simultaneously. Only the broker who actually finds a ready, willing, and able buyer earns a commission. If the seller finds the buyer themselves, no commission is owed to any of the brokers. Exclusive agency listing. In this type of listing, the seller hires one broker exclusively, but retains the right to sell the property themselves without paying a commission to the broker. The broker only gets a commission if they or another agent, not the seller, finds the buyer. Exclusive right to sell listing. The seller hires one broker to exclusively market and sell the property for a specified period. Crucially, the broker is entitled to a commission regardless of who actually finds the buyer, even if the seller finds the buyer themselves. This provides the broker with the most security and incentive to market the property aggressively. Question 407. Under the UCC, in contracts for the sale of goods, the test for deciding whether a buyer has the right to specific performance is if the items being sold are A. Expensive. B. Readily available. C. Unique. D. Both A and C. Correct answer is C. Unique. Specific performance is a legal remedy where a court orders the breaching party to fulfill the terms of the contract, rather than simply paying monetary damages. It's typically granted when the subject matter of the contract is unique and cannot be easily replaced with a similar item on the open market. UCC Section 2716 addresses the buyer's right to specific performance. It states that specific performance may be decreed if the goods are unique or in other proper circumstances. This could include things like custom-made items, rare collectibles, or goods with special sentimental value. Question 408. The following are ways that staging is used to improve the desirability of a home being shown to potential buyers, except A. Removing clutter. B. Replacing window shades. C. Upgrading earthquake insurance. D. Eliminating food odors. Correct answer is C. Upgrading earthquake insurance. Staging is the process of preparing a home for sale by making it more attractive to potential buyers. The goal is to showcase the home's best features and create a positive first impression. This typically involves cosmetic and aesthetic improvements. Earthquake insurance is a financial protection against potential damage from earthquakes. While it's a valuable consideration for homeowners in earthquake-prone areas like San Jose, California, it's not a visual or cosmetic improvement that directly impacts the desirability of the home during a showing. It's related to risk management and financial planning, not staging. Question 409. A potential borrower trying to obtain a FHA loan would apply to A. A broker, B. The FHA, C. An approved lender, D. The VA, if the borrower is a veteran. Correct answer is C. An approved lender. The Federal Housing Administration, FHA, doesn't directly lend money. The FHA is a government agency that insures mortgages, not a lender itself. Approved lenders process FHA loans. Borrowers must apply for FHA loans through lenders approved by the FHA to participate in the program. These lenders can be banks, mortgage companies, or credit unions. Brokers can connect borrowers with lenders. While brokers can't directly issue FHA loans, they can work with borrowers to find an FHA-approved lender that meets their needs. Question 410. Bart, an owner of beachfront property, is aware that the paved pathway to the beach being constructed over the course of a year by Jared, who lives across the street, is an encroachment on Bart's property. Nevertheless, Bart waits until the pathway is completed before notifying Jared that Bart is suing to have the pathway removed. Jared can likely prevent this result by relying on the grounds of A. Laches, B. The statute of limitations, C. The statute of frauds, D. Coastal Commission regulations. Correct answer is A. Laches. Laches is an equitable doctrine that prevents a party from asserting a right or claim when there has been an unreasonable delay in doing so, and that delay has prejudiced the opposing party. In this scenario, Bart knew for a year that Jared was encroaching on his property by building the pathway. However, Bart waited until the entire pathway was completed, causing significant expense and effort for Jared, before taking any legal action. This unreasonable delay, coupled with the prejudice suffered by Jared due to the completed construction, makes the defense of Laches likely to succeed. The statute of limitations sets a time limit for filing certain types of lawsuits. While there is a statute of limitations for actions related to real property, the key issue here isn't necessarily the length of time that has passed since the encroachment began, but rather Bart's knowing and unreasonable delay in acting while Jared incurred significant costs. Laches can apply even if the statutory period hasn't fully run. The statute of frauds requires certain types of contracts, like those involving the transfer of real property, to be in writing to be enforceable. This doesn't directly apply to a situation involving an encroachment and a delay in legal action. Coastal Commission regulations pertain to development and land use within the coastal zone. While they might be relevant to the legality of the pathway itself, they don't directly address Bart's delay in bringing a legal action for encroachment. In summary, Jared's best defense against Bart's lawsuit for removal of the completed pathway is likely the doctrine of Laches. Based on Bart's unreasonable delay in asserting his rights while Jared detrimentally relied on Bart's inaction.